In the hours and days after Billy Chemirmir was arrested in Dallas, police began to retroactively piece together the clues that the killer had left behind. With data from a cell phone Chemirmir voluntarily handed over, they found that he was frequenting many different senior living communities, the Walmart, and several cash-for-gold businesses, like the Diamond and Gold Exchange. They also saw from his OfferUp and Craigslist records that although he said he bought and sold jewelry on the side, he didn't do much buying over the years. He did do a lot of selling. Investigators thought there might be even more victims that they didn't yet know about. They wanted the public's help. Plano's police chief called the media to the station for a press conference. By then, police had identified several other cases linked to Chemirmir, including a report from 94-year-old Ella Lawson in nearby Frisco, Texas, who said a man had attacked her at Parkview, another independent living community. Plano's police chief Gregory Russian took to the podium surrounded by top cops and district attorneys from around the greater Dallas area.
Chemirmir used his healthcare experience to his advantage in targeting and exploiting seniors, some of the most vulnerable people in our community. This is terribly disturbing. In the Frisco case, he knocked a 93-year-old victim from her walker to the floor and smothered her with a pillow. Who does that? We just want to take a moment to express our condolences to the victims and their families who have suffered from these horrific crimes. We're going to make every attempt to identify all the victims in the communities across the Metroplex to fully investigate this case and provide justice for the victims and for their families.
Russian announced that he was setting up a 24-hour tip line manned by detectives so members of the public could phone in with information relevant to the investigation. That was a remarkably rare step for the police to take, as one news reporter was quick to point out.
Good to see you, sir. I do have one question. Setting up a hotline seems to be highly unusual unless you believe there is significantly more criminal activity against Billy Chemirmir.
The police chief agreed, giving the first hint that his team was already starting to realize how widespread the crimes were.
Well, we believe that the way that these crimes were committed, that when you're a senior and you have healthcare issues and you're living by yourself and then you do become deceased, that many people would think right away that's natural causes. And there is not a deep investigation into those matters, so it would be very easy to disguise a crime in that type of activity. So yes, we do think that we want to make sure that we know about any other possible crimes that are out there and look into those. We're looking at those ourselves, going back and looking at unintended deaths and things to try to see if we see anything in those. We also want the community's help as well.
Soon after the press conference, the phone started ringing. With each call, police's list of possible victims started to grow. I'm Charlie Scudder, and this is The Unforgotten: Unnatural Causes. Chapter 5: The Prosecution. Dan Probst called the Plano Police Hotline right away, and his Aunt Kathy's name was added to a list of possible victims. Josh Alleman, the former Edgemere security guard, called the hotline too.
My buddy that I worked with, the one that was there when we caught him, the one that knew my theory, calls me 9 o'clock at night. And first thing he said was, "Josh, you were right. You were right all along." And he told me that Billy was a murderer, that he killed an elderly woman, and he's on the news. And so I was driving home when he called me, and he tells me about it, and I hang up, and first thing I did was I screamed. I yelled in my car. I was just me. I was just full of emotions, just so furious,
Was there any vindication in that you were right?
I think the pain of being right outweighed that, yeah, I was right, but it was the worst thing that you could be right about,
Others found out later, as investigators began putting puzzle pieces together and making the awful phone calls to tell families who had grieved for years that their loved ones' peaceful deaths were anything but. Here's Plano Police Detective John Hoffman.
We didn't just go, maybe this person. We did a lot of research, a lot of investigating, and went, this is beyond coincidence. We need to reach out. That's a very uncomfortable call to make. You get different reactions from it.
One of the calls Hoffman made that summer was to Shannon Dion, whose mother, Doris Gleason, died at the Tradition Prestonwood. This is Shannon.
It was basically, I'm working on this case, this person who has done these things, and your mother's unattended death has come up.
It had been almost a year and a half after her records request showed a pattern of deaths at the Tradition Prestonwood.
You could have knocked me over. There's an old term, gobsmacked. After all this time, it was strange to have this all come up. But finally, this being a possibility, things made sense. As horrible as the sense was, the puzzle came together. I don't have a word to describe when I think about what my mother's last moments. I have nightmares of that.
At the same time, attorneys began deciding how to prosecute Chemirmir. There were multiple jurisdictions with cases, primarily Dallas County and its suburban neighbor, Collin County. Plano, where the investigation really began with Mary Bartell and Ann Conklin, is in Collin County. But the first murder he was charged with, the murder of Kim Harris, was in Dallas. Remember, Kim was the South Vietnamese refugee you heard about in the last episode. Because he was arrested with the proverbial smoking gun of Kim's jewelry box, cash, keys, and more, prosecutors believed it was the strongest case. Dallas would get to try him first on as many cases as they'd like. Then, the Collin County District Attorney would take over. That meant the case soon came under the purview of newly elected Dallas District Attorney John Creuzot. Creuzot was elected top prosecutor in 2018, but he had spent a long career in Dallas and was well known in its criminal courthouse. He had spent 2 decades as a felony court judge. Most people in the courthouse still call him Judge Creuzot, or just Judge. Creuzot is a Democrat and has pushed for progressive equal justice initiatives as a judge and prosecutor. Long before he was elected DA, he was most known for his work in establishing Dallas's drug courts, an alternative sentencing program that prioritizes treatment rather than incarceration. He's considered a reformer, a champion of evidence-based sentencing. And although he worked on several death penalty cases as a prosecutor early in his career, he had never sent someone to death row as a judge and hadn't sought execution for a defendant as DA. In fact, he's worked with prosecutors groups whose goal is to eliminate the death penalty nationwide. Then, Chemirmir's capital murder cases came across his desk. For the first and only time in his tenure as DA, Creuzot decided to file paperwork with the court to seek execution for Chemirmir. Creuzot and I have spoken many times about this case and others. During one of Chemirmir's trials, I mentioned that I'd started work on a podcast about the case. He said he'd be happy to set up an interview and talk through some of those tough decisions that he and his team made when trying the case. But when I reached out earlier this year, he said through a spokeswoman that he'd have to think about it. Then he agreed. Then, before we could schedule a date for the interview, the spokeswoman said he'd changed his mind and declined to answer any of my questions about the case. In the meantime, he sat for interviews with TV documentary crews and cable talk shows about the case. Yet, for some reason, he didn't want to talk to our team about it. I ultimately sent him a list of written questions, which also went unanswered. I wanted to know more about why he made the decision to seek execution for Chemirmir in July 2019. I knew Chemirmir had maintained his innocence, and I know that, although there are some moral questions about the tactic, prosecutors have sought execution in the past as a bargaining chip to force a plea deal with a defendant. I wondered if Creuzot had made the same bet before Chemirmir's trial. The DA declined to answer those and many other questions. Whether it was a decision based on the severity of the crimes or just a prosecutorial tactic to pressure Chemirmir, the death penalty case sped toward trial. In February 2020, a date for the first trial, for the murder of Kim Harris, was set for the following spring. Then, something unexpected happened.
This is breaking news from Channel 7 Eyewitness News.
Several breaking developments tonight in the coronavirus outbreak.
Defendants, judges, and attorneys are feeling the impacts of COVID-19.
The COVID-19 pandemic halted all court proceedings across the country. In many places, it put an already backlogged system into even greater jeopardy. As the lockdown weeks turned into months, jurists began experimenting with virtual hearings and even virtual trials, not without error. You may remember this Texas hearing about a fairly banal civil forfeiture case that went viral in early 2021.
Can you hear me, Judge?
I can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm here live. I'm not a cat.
I can see that.
Which honestly gets me every time. I remember covering courts, well, really covering anything at that time, was rife with those kind of technical errors and Zoom snafus. But in criminal trials, when a defendant's guilt or innocence is at stake, there were serious questions about whether a virtual trial was even constitutional. How could you ensure that the jury was paying attention to testimony with social media and all kinds of other distractions just a click away? How could you be sure that those jurors had reliable Wi-Fi access and that a key witness's testimony wasn't dropped? What about the defendant's access to reliable internet? Or the ability to cross-examine a witness effectively if they're on the other end of a computer? But at the same time, what about a defendant's right to a speedy trial? Wouldn't delays infringe on that Sixth Amendment right? Death penalty cases in particular were thrown into limbo by the pandemic. While other smaller cases managed to resume virtually, there were too many constitutional concerns with something as high stakes as capital punishment. There was no guarantee to a fair trial with the many pandemic-related restrictions in place at courthouses across the country. Because the punishment is so extreme, there are a lot of guardrails on how American courts use the death penalty. It's a two-part trial where, at first, jurors hear evidence to decide if the defendant is guilty, whether or not they committed the crime. Then, if the jury does return a guilty verdict, they enter a penalty phase, where prosecutors try to prove that the convicted defendant should be put to death. In Texas, it's not about how heinous the crime was, but instead, prosecutors must prove three very specific questions. First, jurors must decide that the defendant intentionally killed the victim. Second, they must decide that there is a likelihood that the defendant will continue to commit violent acts, even while in prison. And finally, they must decide that there are no significant mitigating factors, like mental illness, that would preclude a death sentence.
You can't just decide that question based on the number of victims or what happened during the murders, but you have to also ask about the defendant, mental illness, mitigation. Is this the worst of the worst defendants, not just the worst of the worst acts? That's how death penalty law is structured.
That's Brandon Garrett. He's a professor of law at Duke University and director of the Wilson Center for Science and Justice. He's done a lot of research on the use of the death penalty in the United States.
Some of these cases can be quite confounded, where you have individuals that do horrific things precisely because of illness that they aren't wholly to blame for.
Texas was once the death penalty capital of the U.S. In 2000, the state executed 40 inmates, but that number has slowly declined in the years since. Last year, Texas carried out 8 executions. And fewer people are going to death row, too. In the past decade, Texas juries have handed out an average of 4 death sentences annually, down from nearly 50 in 1999.
Texas used to be the nation's leader in death sentences, and now it is absolutely not. And that's true across Texas, but it's also true across other states that used to be known for imposing the most death sentences. But there's really just a trickle of death sentences anywhere in the country.
The reasons for this drop in executions, Garrett says, fall into a few main categories. For one, it's expensive. The cost not just of execution, but the lengthy prosecution and appeals process on death cases can run up a major bill for county taxpayers. It can be decades after a capital murder conviction before an execution is carried out. And all the while, lawyers on both sides have to shepherd the case through the courts. Which brings up another problem. It's time-consuming. Lawyers have to research the defendant's mental history and entire past to see if there are any mitigating factors that may be cause for or against execution. In the lead up to Chemirmir's trial, Creuzot even said that because he was in his 60s, he didn't expect to live long enough to see Chemirmir executed, if he was given the death penalty. Then there's the ethical problems with capital punishment, especially in an era where DNA evidence shows just how often the justice system can convict the wrong defendant. Plus, in Texas, there's another option. In 2005, Texas legislators passed a law that made the automatic punishment for a capital murder conviction life in prison without the possibility of parole. Only in cases where prosecutors choose to seek the death penalty is it considered by a jury. In other words, a defendant convicted of capital murder in Texas will die in prison, regardless. Here's Garrett again, the death penalty expert.
It takes so many years for a case to proceed to an execution. I think many prosecutors have decided, is it really worth it to put the victims through that, to have everyone wait 20 years for an execution date? A life without parole sentence provides certainty much faster, which the victims often appreciate too. There are many more victims' families that say they don't want to go through a capital trial, but then also all the aftermath, where there are different challenges, execution method challenges, just waiting for execution dates to be set. The victims have to sort of revisit the case time and time again over decades. And there isn't that same process involved with a life without parole sentence, for better or for worse.
So when Dallas County District Attorney John Creuzot decided to seek the death penalty against Chemirmir, those were the hurdles that his team would have to clear. They'd have to research Chemirmir's past, and because he was a Kenyan immigrant, that would mean flying overseas in the middle of a global pandemic. It would also mean the county would have to front the bill for Chemirmir's public defender to go to Kenya, too. So he could ask questions of friends and family members, look for clues, and see if there were any mitigating factors. Plus, Chemirmir was, by all accounts, a model inmate. He kept to himself. He was quiet. He was polite. Prosecutors would have to show the jury that he posed a threat to other inmates and prison guards, and there just wasn't any evidence to prove that. So, in the summer of 2021, just a few months before the trial was set to begin, Creuzot arranged a video call with all of the victims' families. One of those families recorded the conversation and shared it with me. This is the first time that it's been played publicly.
So anyway, as I said, I'm John Creuzot. I'm the district attorney for Dallas County. And first of all, I want to extend on my behalf and on behalf of this office condolences for your losses. The issue is, where are we going forward? Are we going to pursue a death penalty or not? And I'm going to get to the point, and that is that we're going to try him not for death, but to convict him on more than one case. So we get convictions that in case one is reversed for some reason that we cannot foresee, or some mistake, and these happen in these cases by the judge or whatever, that we can be certain that we don't have to go back and try to retry a case again and put everybody through the trauma of that. We anticipate we'll get 2 convictions. We anticipate that we'll get 2 life sentences. There will be life sentences without parole. He will never see the light of day, and we can go on from him.
When Creuzot asked for questions, the first was about whether reversing course would eliminate any leverage the prosecutors would have in trying to get Chemirmir to admit to his crimes. Glenn Fitzmartin, Creuzot's felony trial bureau chief, who would lead the prosecution, said he already tried that.
Is there any way we can, taking this off the table, affects your leverage? And you guys are the experts, so I'm not going to criticize.
I know what you're asking, and we've tried that that tactic. And so I have met with his lawyers on a number of occasions. We all met with Mr. Chemirmir. And I explained to him what we were planning on doing and laid out, how much proof we have. But he is not budging. There was no budge whatsoever in those meetings.
Fitzmartin said that even in private, Chemirmir was steadfast in his claims of innocence, a position he had maintained since the evening of his arrest.
It would have been, obviously easier for everyone if he would just have pled guilty to all of these cases and then told us anything else. I mean, that was kind of an original deal that I had told most of y'all, if I would hear that from him, that I would come back and talk to you about us working a deal out with him. Doing it this way, I know that I can get a trial of this nature in faster because there is no punishment phase to the trial. So the things we're talking about going to Kenya, or the things we're talking about dealing with his mind or his brain or any kind of mitigating circumstances does not matter at this point in time, because there's only one possibility. It's either he's getting a life without parole or nothing. And the luxury that I have, and what Mr. Chemirmir doesn't understand, I don't think, is I'll go forward on every one of these until he is locked up for the rest of his life. I mean, that's just the way it is.
Here, another victim's family member asks about the prosecutor's plan for trying additional cases.
What I understand you to say is you're going to, let's say the first one gets a conviction and the second one doesn't, then you will go to your third choice and try them again until you get 2 convictions. And if C does, then you'll go to D.
Fitzmartin, the lead prosecutor under Creuzot, answers first.
I've never thought along the lines of me losing a case, so I didn't actually ask Judge what he thought about that. I mean, not to sound egotistical.
The answer is yes. We are not going to stop until we have 2 convictions on him, and it doesn't matter. We don't anticipate that he's going to get a not guilty on any of these cases, but if he does, or some lesser offense because of some circumstance we cannot anticipate, we're going to go forward until we get 2 life without parole sentences.
It's clear that the prosecutors planned for 2 speedy verdicts of guilty. There's no way they could have expected what happened next. Sometimes, when a defendant like Billy Chemirmir is charged with a lot of crimes, the judge will decide to bundle up the charges and try them all at the same time. It can save time and money and avoid the need for a lot of repeat testimony. Early on, long before the trial was initially scheduled to begin, the judge in the case, Raquel Rocky Jones, decided that the case would not be tried as a bundle. Instead, each would need to be prosecuted individually. This isn't uncommon. Each crime was committed individually, so it would need to be prosecuted individually. Because it had the strongest evidence, prosecutors decided they would first try Chemirmir in case F1875401, the indictment number assigned to the murder of Lou T. Kim Harris. Federal rules about evidence also ban prosecutors from bringing in evidence of other crimes when trying to prove the guilt of a defendant. In other words, jurors in the Chemirmir case would be allowed to hear evidence about just one case, not the dozens he'd been accused of. In fact, if Creuzot had decided to seek the death penalty, many of those evidentiary rules would be altered when the case reached the punishment phase. But since the automatic sentence from a guilty verdict would be life without parole, those other cases would need to be hidden from the jury. But the federal rule against showing that evidence, known as 404B, has an exception. Prosecutors can ask judges to allow evidence if it proves motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. With that limited window, lead prosecutor Glenn Fitzmartin chose to include details about 2 other cases. First, he wanted to tell jurors about Mary Bartell, since her story explained how police caught him. Fitzmartin also wanted to include the case of Mary Sue Brooks, since security camera footage showed Chemirmir following both Kim and Sue at Walmart just a few hours before they were found dead. Fitzmartin argued that that would prove to jurors that Chemirmir had a common plan in killing both women. The start of the trial in November 2021 was unusual for several reasons. On the first day of jury selection, news broke that Chemirmir's lead defense attorney, Philip Hayes, had been arrested for solicitation of prostitution. He ultimately pled guilty to that charge in exchange for probation. Some of the potential jurors had seen the news, so Hayes decided not to attend the trial. His second chair, Kobe Warren, would lead Chemirmir's defense. The trial would also have a litany of COVID-era protocols that made it unlike a normal capital murder case. The jury would be socially distanced in the gallery, not the usual jury box, meaning there was no room for the public, usually just family members and journalists, to view the proceedings. The judge agreed to a live stream feed that would be broadcast online for the reporters to watch in the hallway and for the families of Chemirmir's victims to watch in a room in the district attorney's office, a few floors above the courtroom. Also, the attorneys, judge, witnesses, and jurors would need to be masked. The prosecutors used clear plastic face shields, and witnesses were allowed to remove their masks after they had been sworn in. But for the first few days of testimony, Chemirmir wore a blue disposable face mask, leading to several cases of mistaken identity. Like this moment with Detective Paul Martinez, who you've heard from already.
At some point in time, were you aware of the arrest of Mr. Chemirmir?
Yes.
Do you see Mr. Chemirmir in the courtroom today?
I see somebody that could be, with court's permission, could he take his mask off? Yes. The individual to my right with the blue mask that you pulled down with the glasses, I believe it's Billy Chemirmir.
With the mask on, witnesses asked to identify Chemirmir also pointed to his tie choice. In every day of the multiple trials, Chemirmir wore a wide tie with zebra stripes. Fitzmartin presented the evidence in the order that police discovered it, which meant an overlapping timeline that jumped from case to case. It was confusing to hear it laid out that way in court, even for those of us who knew the case inside and out. Unfortunately, the woman who had survived Chemirmir's attack and helped identify him to police was unable to attend the trial. After Chemirmir had attacked her, Mary Bartel's recovery was slow, and her health never really completely rebounded. She died in February 2020, nearly 2 years after her attack. But before her death, Mary gave sworn testimony on a video recording, which jurors watched on the first day of the trial. We played you a little bit of this testimony in the first episode, but she had much more to say about that morning.
You know, they say, before you open the door, ask, who is it? Well, if it's one of my neighbors, they're probably as deaf as I am, and I would never know who was at the door. So anyway, the door was opening inward, and when my eyes were just fixated on these green rubber gloves that I saw. I knew instantly when I saw those 2 green rubber gloves. Number 1, I should not have opened the door. Number 2, my life was in grave danger.
Immediately, he was inside her apartment.
And he said, don't fight me, lie on the bed. So I did as he said, because I knew I could not overpower him physically. He just smashed a pillow down hard over my face and my chest, and I just couldn't breathe.
The next day, jurors heard from Richard Reinhardt, Kim Harris's son-in-law, the widower of her daughter Lone.
What kind of person was she? She was a very fun person, very, very humorous, very generous.
The defense hardly put up a case. Colby Warren, the second chair, asked few questions and called no witnesses. This also isn't terribly uncommon. Chemirmir's team used a strategy that relies on the state's burden to prove beyond a reasonable doubt that he was guilty. In our justice system, the defense does not need to provide any evidence. If the state fails to prove its case, the jurors are instructed to acquit, and that's what the defense was hoping for. The prosecution unintentionally did allow Chemirmir an opportunity to give his side of the story, though. After his arrest, police officers from Dallas and Plano interviewed Chemirmir for hours. For the jurors, Fitzmartin played video of the interview, of Chemirmir sitting in a room at Dallas Police Headquarters, calmly and consistently claiming that he was innocent. He said that he did buy and sell jewelry as a hobby. He said that he had just bought Kim Harris's jewelry box from someone he met online. Here's Fitzmartin asking Dallas Police Detective Brian Tabor about Chemirmir's alibi.
The story that he was giving you, did you buy any of that story at all?
I did not believe anything that he was telling me, especially, just his timeline between what he did and how he met people. I never believed that the people existed that he's bringing up. The accounts that he was going back to, he was starting to want to give any kind of details, and that would have been for earlier in the day. So, yeah, of course, I didn't believe anything he was saying.
It's impossible to guess how long a jury will take with any given case. Sometimes a difficult case will come back within minutes. Sometimes a very straightforward one will take days. But when the jury got this one on a Thursday afternoon, it seemed like it would be over and done with fairly quickly. I waited in the hallway outside the district attorney's office with the families of the victims. We discussed the evidence, what new details surprised us, what we thought would be key elements for jurors to consider. But as time dragged on, one question kept coming up. What's taking so long? What could they be talking about? 1 hour passed. 2. 3. In the early evening, the judge sent the jurors home for the night, with instructions to return and continue deliberations first thing in the morning. That morning, we thought maybe they just needed a night to sleep on it. One quick vote, and we'd have a verdict. There was quick word, but it wasn't a verdict. Just before 10 a.m., the jury foreman sent a note to the judge. One juror will not deliberate from her vote, the note said. The judge sent a note back telling the jury to continue until they reached a unanimous verdict. An hour later, we are hopelessly deadlocked, 11-1. The judge told them to continue. Just before lunch. We remained deadlocked 11-1. After additional deliberation, we perceive no change. Then, the judge drafted what's called an Allen charge, also known as a dynamite charge. It's basically a final come-to-Jesus moment for juries that seem unable to reach a decision, and particularly encourages jurors in the minority to reconsider their position. Defense attorneys often object, and did in this case, saying that such charges put undue pressure on jurors to ignore any doubts they may have about the evidence against a defendant. Judge Jones's charge was firm, but stopped short of encouraging that lone holdout to reconsider. This is Judge Jones reading her new instructions to the jury.
Members of the jury, if this jury finds itself unable to arrive at a unanimous verdict, it will be necessary for the court to declare a mistrial and discharge the jury. The indictment will still be pending, and it is reasonable to assume that the case will be tried again before another jury at some future time. Any such future jury will be impounded in the same way this jury has been impounded, and will likely hear the same evidence which has been presented to this jury. The questions to be determined by the jury will be the same questions confronting you, and there is no reason to hope the next jury will find these questions any easier to decide than you have found. A considerable amount of time and effort has been expended in bringing this case before you.
Judge Jones told the jurors that it was their duty to consult with each other and consider each other's views. She said their goal, still, was to reach a just verdict.
With these additional instructions, you are requested to deliberate in an effort to arrive at a verdict that is acceptable to all members of the jury if you can do so without doing violence to your conscience. Do not violate your conscience, but continue to deliberate. And it is signed by me, Judge Raquel Rocky Jones, presiding judge of the 203rd Judicial District Court.
Just 1 hour after that Allen charge, the jury had another note.
We remain at an impasse with no hope of resolving to this verdict. Deadlocked 11-1, and it is signed by the foreperson of the jury. State, do you have a response in...
Judge Moses, you got the court's decision.
Thank you. And Mr. Moore.
Respectfully, once again, on behalf of Mr. Chemirmir, we would move this court for this trial at this point. This is the fourth, I believe, total note, and the third consecutive note of the jury stating that they're 11-1 deadlocked and at an impasse and unable to reach a verdict unanimously. So we believe at this point it's only fair and in the interest of justice in state speak for Ms. Strong. What I'm here. Thank you.
So based on all the notes and all the information received, the court will find a mistrial has occurred or a hung jury has occurred with a deadlock 11-1.
A mistrial. It was shocking for all of us. For the families, of course, it was a horrible delay, an extension of their stay in the purgatory of the courthouse. For me, it was an unexpected end to an excruciating week. I'd arrived every day at the courthouse before dawn and left long after dark, after the newspaper's deadline each night. I was tired, overworked. Covering murder trials gavel to gavel is always tough, and I'd committed so much extra time to this case in particular. I'd prepared for an end to this story. Either Chemirmir was guilty or not guilty. But for it to be neither? I was perplexed and exhausted and just wanted to be done with it. I'd thought about writing a book about the case or maybe making a podcast like this one. But after the mistrial, I packed up all my notebooks and files and put them away. I wanted to move on, find a new story to work on, stop wasting time on this case. Then, one morning, a few weeks later, my phone rang.
Hello, this is a collect call from an incarcerated individual at Dallas County Jail.
Yes, Kelly, this is Billy.
Billy Chemirmir was ready to talk. Next time on The Unforgotten, Unnatural Causes. The Unforgotten is a free-range production. Season 2, Unnatural Causes, is created, written, and hosted by me, Charlie Scudder. Our producer is Wes Ferguson. Associate producer is Monica Watkins. Audio editing, engineering, mixing, and mastering by Austin Sisler at Eastside Studios in Austin, Texas. Theme song and sound design by AJ LeGrand. Wes Ferguson is the executive producer at Free Range. Special thanks to the Dallas Morning News and the Division of Journalism at Southern Methodist University's Meadows School of the Arts.